Okay, hello, everybody. Hello. Let's get ourselves sorted out here. Hi, everyone. Gotta, here we go. Is this okay? I think should bump it up a little bit. Good morning, everyone, or afternoon. Oop, depending on where we're at. Hopefully that didn't break. Let's take a look. Nope, it's good. It's good, everybody. No worries. We're good to go. Hello, welcome, everyone. Welcome. I had forgotten to put 12 o'clock Central on my little heads up, but hopefully that's all right. So, good afternoon, yes. It's afternoon for some, morning for others, evening for others. Well, welcome, everyone. We had a new order that came out yesterday, kind of past my time that I could do a live. So I thought, well, let's just do it today then. Let's just, set it up and knock it down. So we had a lot of stuff going on over here in the legal world. So we've got lots of things. Oh my goodness gracious, everyone. Lots. So, oh my gosh, 2-6, so busy. So busy. And it's difficult to pick which thing to post about. We have two lawsuits going right now where we have contempt of court for the Trump administration is on the table, and like 70 other lawsuits. You've been waiting. Oh, okay. Yeah, well, hello, Deborah. Hello, good afternoon. Right. Mo Girly Girl, hello, welcome. This is one of the many lawsuits. I am kind of needing to take some time to go through the executive order lawsuits because there just are so many. I have several things I'm trying to get done here. I've got our Declaration of Independence still that I need to post about. I have our SAVE Act here to post about. I have a couple of questions regarding state proposals that people are asking about. So, that should be very interesting. Is this the one the judge just dismissed? Yes. So she denied the temporary restraining order, and I'm going to go through that order with everyone so we can kind of understand. We had, they put this request in for the restraining order, and there were some problems with it. There were some problems with it being way too broad. And if you're asking for a restraining order and it's too broad, it's very likely going to be pushed down. So, is this a new lawsuit? No, this is not a new lawsuit. This lawsuit was I use that term loosely. I think this one was filed the 13th. So I guess it's typically we would call that new because it's only been 6 days, but under this administration, no, it's not not particularly new for the new information to be filed. Now that I don't know, Stephanie, that I don't know. Because I've not even gone through here. It's looking like we do have some kind of a briefing due by 5 o'clock today, but I don't know all the deets yet. I've kind of taken a minute to just go through it. I'll be going through it with everyone here first. So good morning. Hello, WebDeb. Hello. Saying all along there needs to be proof of harm. Yes, so the proof of harm piece, and again, I'm just waiting a few minutes here so everyone can get their notifications. They have been kind of going out late. But the problem when you don't have a specific harm that you can put your finger on, right, or hang your hat on, is that you've got standing issues. And so we've kind of been talking about that, right? We've been talking about, well, where's the harm? What's the harm that's been going on rather than just what we think the harm is going to be. And sometimes the future harm can be used, but courts don't like to do that. They prefer to actually see a harm. So injunctions are in there to ask the court to stop everything before there's significant harm. So, I mean, that's possible, but then the court's, though, going to need a pretty good argument. More info. Yeah, they need to just narrow it down. Good morning. Good morning. They need to narrow it down. That's the problem. And we'll go through the order here in just a couple of minutes. It's too much. They're just asking for too broad. Under qualified versus state attorney generals, judge is unfair. I'm sorry, I don't even know what that means. I don't know what that means. Hello, your Aunt Brandy. Hello, Brandy. Yes. How high is the qualification for a federal prosecutor? Well, you can go ahead and Google that on the Google. Yay, we're back. Yes, Carol. Have you seen the new budget? No, I've not, Felix. I'm afraid. You're not scared for informing the public. Well, that's a great question, Edith. I have had some troubles and continue to have some troubles with people being frustrated with me for sharing this information. But, I try to be pretty private and keep my personal information pretty private as best as I can. So I'm feeling okay about that. You're fabulous. Oh, thank you so much. I appreciate that. Rain from Colorado. Hello. Welcome. So why are you hiding the information? I'm not sure what you mean by information. This is a court document. It's been filed, public record here. That's a them problem. Well, yeah, I think so. Oh, you're welcome. Of course. Yeah, I just keep on doing what I'm doing. It's bad. I'm not surprised. I just keep moving forward, everybody. We have to keep walking through this until we get to the other side. What do you think about AOC? If you mean like the threats, she, one of the things about AOC that some people forget is that there were people that had, and are now pardoned, that had been plotting to, assassinate her. So she lives with that every day. She lives with that fear, and she keeps going forward. She keeps saying, you know what, we got to keep moving on. Restraining order on the Judge T could be overturned. So, I'm not sure yet. We've got multiple. We've got a total of, so far, as of right now, we have 12 lawsuits against Elon Musk and Doge. And I'd say 3/4 of those have restraining orders on them regarding information. This is the biggest one, in my opinion. This is the most impactful because we have all of these states and their attorney generals filing here. So again, we will see by probably tomorrow. We've got more information coming in on how to put together a restraining order. I mean, you have to be specific. You have to have a narrowly tailored, least restrictive restraining order. That's just the rules. So, they may not like, all of these states may not like what's happening with Mr. Musk and them and a lot of other people, but you still got to follow the rules. Everybody's got to follow the rules. Who's left to enforce these orders? We will see. Yes, I did just start. We will see. Right now, we've got only 2 out of the, 75 cases where the court has said you are not in compliance and you need to be, or we're going to have some trouble. So I'm keeping my eye on 2 cases, and those have to do with the frozen federal funding. One's out of Pennsylvania, the other's New York. So I'm keeping my eye on those 2 cases. Those are the ones that are moving forward. The Pennsylvania one, I think, just had a writ of cert requested within the last 48 hours. So that one's the one that has moved the most or the highest. And we'll kind of see. We got to kind of wait and see how the courts want to take care of it. Well, you never know. You never know, but most likely no. He won't be following that. So we can do how to file a motion. Can we do how to file a motion in state superior court? I can put something together. I have to be careful, though. The trolls are really busy. I got to be careful. Every state is going to be just a little bit different. We've got general ways of filing things, but depending on your state, they're going to have different requests, as well as depending on your jurisdiction. Enrolled in school to be a paralegal. Oh my gosh, really? Oh, that's fantastic. That's so sweet of you to say. I appreciate that. Oh, how kind of you. I tell you what, that paralegal road, everyone, is an amazing road to go down. the information that they teach in paralegal programs in the United States, it's just law school light. And I only say light because rather than 1,000 cases to read, you have 100 cases to read. And it's just such a great area to go into. What are they hiding? First of all, who's they? We need more of them. We certainly do. We certainly do. My goodness, they are the equivalent of our nurses, and we need them desperately. We could not do our jobs without our paralegals and our legal secretaries. So those, of course, are different. Those are very different jobs, but we need them. And the Navy doing paralegal. Oh, good for her, KO. We love that. We love it. So welcome in, everyone. Wanted to give a chance for the announcements to go out, just to say, hey, good inexpensive schools for paralegals. Now that I don't have specifics on, that you'll have to kind of, yes, and procedure, very important. You'll have to kind of take a peek at that. And there are some paralegal programs that are face-to-face versus online. I know some are completely online, and that has to do with how you are able to learn. Love the red nails spicy. I gotta have a little spice these days. There's the trollers are here. You did yours online. Oh, we love it. Yeah. I mean, if you can learn that way, if that works for you, that's fantastic. Some people really struggle. For a legal question, I can't give any legal advice, Eliza, but if you've got an academic question or a question on how things work, sure. My DMs are open. Right. DC lawyer. Who's a DC lawyer? Which one? Because we've got, this is in DC. Head against the wall reading oh my gosh, Jack, I tell you what, the executive orders, man. That's a lot. Hello, Swish. Good afternoon. Hello. Helping with, right. So, Cody, the thing is, I have no problem with Elon Musk doing, whatever it is that he's going to do, but he needs to follow the law. There's protocols and procedures, right? We have steps. So if he had followed steps 1 through 5, we wouldn't have any lawsuits. He could still be in there doing what he wants to do here, but you got to follow the rules. And that's the issue here. He's not following the rules. And so anyone who's not following the rules is going to be a problem. Yeah, he will follow he's not, though. He's not following the rules. Yeah, I know. I know. Yeah, so, follow the rules. File your notices, give people information, make your requests, go through proper protocols, and then have at it. But if you're not going to follow the rules, you're just going to kind of come in and bulldoze everything. That's kind of, I'm going to call you out on it. I don't care who you are. You follow the rules, man. What about the executive order where the president and the attorney general interpret the law? I've not seen that executive order yet, Lindsay, but I will say that it's up to the courts to interpret the law. The law is not interpreted by the executive branch. It's supposed to be enforced. He's not following. Yeah, it does bother me that he's not following the rules. Yeah, because we have laws, and laws are supposed to be followed, right? Yeah, that's how they control people. I agree. Courts are corrupt. I don't even know what that means. So, all right, we're going to, oh my gosh, everybody. No, I'm getting asked here. Man, I tell you, I've had some trouble with people trying to come in and bomb my live. So here we go. Let's go ahead and reading a statement of, oh my gosh, Jim, don't get me started, man. I got things to say about that. Let's go ahead and get into the meat and potatoes here. This is a lawsuit against Mr. Musk and the Doge situation. Again, this has to do with the allowable access and the administrative rules that are being violated and the Constitution pieces that are being violated. We have this filed in DC. Of course, Judge Chutkin is presiding, which is always very interesting. She does a pretty good work on the bench, in my opinion, when it comes to constitutional questions. Now, we had a restraining order request here from the plaintiffs asking for Mr. Musk to like stop what he's doing, but their ask was way too broad. They have a 54-page request here for a temporary restraining order. I've kind of gone through that information, and Judge Chutkin's like, dudes, narrow it down. So I'll take you through her order here. Let me get my sticky note ready, and then kind of talk through the issues that we have here. Because it's a big whoop-de-doo doesn't mean you can cut corners on your legal filings. So we've got here, we're just going to say the state of New Mexico. There's a whole bunch, but they're the first listed. New Mexico et al. Versus Musk and Doji here. And again, there's some pretty big federal statutes that are being violated when it comes to the creation of this committee or organization or administrative agency. I mean, the creation of these kinds of things is done by Congress, and not just because Congress is like, we'll do that. No, it's because that's the law. So for someone to be creating this organization without going through Congress, that's a violation of federal law. So, thank you so much. Thank you so much. Yeah. Like you play Galaga. Oh my God, I love Galaga. I love it. I love it. I love it. All right. So we have here, restraining order has been denied. So, and then I will dive in here and just start reading, and we'll leave my moderators in charge of the trolls here. And of course there are a lot. So, make sure that you are taking care of your mental health. All of money. About the case. Absolutely, Pam. Yep. The citizens of the United States could sue. Kim, we already have a lawsuit that's been filed, a class action suit on citizens of the United States with questions regarding the privacy issues going on. We do. We have one. Will we have more? Probably so. I will be going over that lawsuit relatively soon here. Mutant block trolls. Yeah, I think, just go ahead and bump him. We had, he's not the head of Doge. It doesn't matter, Edith. It doesn't matter what he is or is not the head of. He's there physically, and he's telling people to do stuff. So that's where you can get into trouble. Can we all sign up for that class action? It's a good question. They're definitely asking about it. So how do we get on the class action? I'll have to do a full post on that one involving that case, because they're assessing right now if they've got enough grounds for it. That's not been determined. If they do have enough grounds for it, then that'll be really interesting for us to go through it. So here we go. Welcome in, VC. Yeah, I know. Steffi, welcome. Tay, welcome. I've got a lot of amazing moderators in here, so please be respectful. This isn't a legal debate. This is just me explaining some stuff here. So we're going to try to stay on target so everyone can understand what's happened here. All right. Here we are, everyone. This is the lawsuit regarding Mr. Musk and the Doji situation, and this is the case number up here. I will be reading through document 29. This has been filed on the 18th. This is a memorandum and opinion of the court here. We got your back. Oh, no problem. I just want to make sure that y'all are okay. Some of these comments are just so awful. All right, state of New Mexico. And when we say state of New Mexico, we actually have Mexico, Arizona, Michigan, California, Connecticut, Hawaii, Maryland, Massachusetts, Minnesota, Nevada, Oregon, Vermont, and Washington. These are a whole bunch of state AGs. Here we go. Plaintiffs, 14 states represented by their attorney general, have filed an emergency motion for a temporary restraining order, or a TRO, against Elon Musk, the U.S. Department of Government Efficiency, DOGE Service, U.S. DOGE Service Temporary Organization, and President Trump. Emergency motion has been filed here, so if you're interested, you can look that up under this case. It's all available for free online. Based on the parties' briefing oral argument and the current record, the court finds that plaintiffs have not carried their burden of showing that they will suffer imminent irreparable harm. So this is the burden that the plaintiffs have here, that they have to meet. And she said, you haven't met it. And they just met yesterday in court. So absent a temporary restraining order, and therefore plaintiff's motion is denied. So let's take a look and let's try to figure out what it is that made it so we were denied. Here's our background. On July 20th, whoops, gotta stop. Tea break. We're gonna take a lot of tea breaks today, everyone. Doesn't end the way y'all. Yeah. I mean, again, we gotta be careful. We gotta follow the rules. Everybody has to follow the rules. You want to go in and start, firing people and pulling money out and dissolving stuff. You can do that. Just follow the rules. On January 20th of 2025, Trump established the Department of Government Efficiency and a subsidiary organization, U.S. Doge Service Temporary Organization. Again, these kinds of departments are created through Congress, and there's an actual federal act that has to be followed when we're creating these kinds of things by executive order. Elon Musk directs the work of Doge personnel, but is formally classified as a special government employee, which is, again, fine. And then we're citing that, classifying Musk as a non-career special government employee and senior advisor to the president. Here. And plaintiffs brought this action for declaratory and injunctive relief, alleging that Musk's actions violate the Appointments Clause of the U.S. Constitution. Because he has not been nominated by the president and confirmed by the Senate as an officer of the United States, in the reciting Article 2. And that Musk and Doge lack statutory authority for their actions. Plaintiffs allege Musk exercises virtually unchecked power across the executive branch, making decisions about expenditures, contracts, government property, regulations, and the very existence of federal agencies. They claim that in the last few weeks, Musk and Doge defendants have gained access to sensitive data, information systems, and technological and financial infrastructure across the federal government. Defendants have allegedly used this unfettered access authority to terminate personnel, place entire agencies on temporary leave, transfer data to outside servers. And then, again, this is something that's been going on in the Southern District of New York through the DOJ as well. So take over physical office spaces and terminate contracts valued in the hundreds of millions of dollars. Defendants concede that there is no apparent source of legal authority granting Musk or Doge the power to order personnel actions at federal agencies, but do not deny defendants are taking such actions. So this is the key here that we can use repeatedly here. We've got defendants are conceding there's no source of legal authority. So, all right, don't have to prove that because they're saying, yep, that's right. We have no source of legal authority to do what we're doing, and we are doing it. So we don't always see that. Sorry, everyone. It is so cold where I'm at today. So, all right, we've got our first footnote. Number 1, defendants filed a notice and declaration. I need to switch pens. Here we go. And declaration by Joshua Fisher, the Director of Office of Administration, responding to the court's questions during the February 17th hearing. Defendants state, quote, neither of the president's executive orders regarding Doge contemplate, much less furnish, authority to order personnel actions at any of the agencies specified. Based on the executive orders, plain text, new career appointment hiring decisions at each federal agency shall be made in consultation with the agency's Doge team lead, and agency shall not fill any vacancies for career appointments that the Doge team lead assesses should not be filled unless the agency head determines the position should be filled. And then, at a minimum, this language contemplates Doge's authority over personnel actions. Defense counsel is reminded of their duty to make truthful representations to the court. Whoa, that's a smackdown right here, everybody. Let's take a minute to review that. This is something you don't want your judge to say to you. Oh, my gosh. Yeah, make sure that you are being sarcastic in a way that the moderators can tell, because at this point, some of those things that you think are sarcastic, people are actually believing and doing. So just to make sure. Okay. Yeah. Hello, Estelle. Welcome. So there's footnote number 1. Here we go. Moving over. On February 14th, here we go, I've got my new pen up and running. On February 14th of 2025, plaintiffs moved for a temporary restraining order to enjoin 11 categories of conduct by Musk and Doge. And that's a lot, all right? So that's a lot. And we have footnote number 2 here as well. And plaintiffs asked the court to enter the following order. Mr. Musk, U.S. Doge Service Temporary Organization, along with personnel associated with these entities, are ordered to identify all the ways in which any data obtained through unlawful agency access was used, including whether it was used to train any algorithmic models or create obtained derivative data, and destroy any copies or any derivative data of defendants' possession, custody, or control, and that they are temporarily enjoined from. And this is something I did go over in my last live, and we talked about that. We talked about how this was so broad that the judge may have a problem with it, and it looks like she did. This is what they're asking for. And think to yourself as we go through these, how we could narrow it down. Can we be more specific so we don't have such a huge sweeping restraining order? One thing judges don't want to do is make a restraining order so broad that they're going into court 3 times a day trying to tighten it up, right? Because if Doge does something, then the plaintiffs can say, well, you violated it, and Doge can say, well, we didn't think we did, and it'd be over and over and over and over and over again. So we'd be having litigation forever, and that's why the courts try to be very specific and very particular when it comes to that. So here's what they were asking the judge to enjoin Doge from doing: ordering any change in the disbursement of public funds by agencies, extending offers on behalf of the United States that would bind the government to an appropriation that's not been authorized by law, canceling government contracts, disposing of government property, ordering the rescission or amendment of regulations, making personnel decisions for agency employees, taking steps to dismantle agencies created by law or otherwise asserting control over such agencies, including placing employees on administrative leave. So this is super broad, but if they were able to narrow that down, this would be a great one. To really start to sink your teeth into, making sure that language is very particular. Accessing sensitive and confidential agency data, using agency data for other than its authorized purpose. Again, it's too broad. Altering agency data systems without authorization by law and without taking all appropriate protections against cybersecurity risks. So again, all appropriate. What does that mean? We need to have that defined. Or J, engaging in any other conduct that violates the Appointments Clause or exceeds statutory authority. Right, so too broad here at this point. That day, the court held a hearing during which plaintiffs significantly narrowed the scope of their requested relief. So that's good. They knew that it was too broad. At the court's request, plaintiffs filed a revised proposed TRO, which asked the court to enjoin Musk and Doge defendants from, so let's take a look at their new request. 1, accessing, copying, or transferring any data systems in the Office of Personnel Management and the Departments of Education, Labor, Health and Human Services, Energy, Transportation, and Commerce. And 2, terminating or otherwise placing on leave any, here we go, officers or employees within those same agencies. And we have footnote 3 here. In light of the narrowed scope and the parties' briefing, the court heard further argument on February 17th. So they narrowed it down. They had 3 requests, compound sentences. Hello. Let's take a look here at footnote number 3. Plaintiffs submitted the following proposed revised order. Defendants Elon Musk, U.S. Doge Service, U.S. Doge Service Temporary Organization, and their agents, officers, and employees, or anyone acting in the active concert with them are temporarily restrained from A, accessing or continuing to access any data systems in the information and code contained within those systems, including but not limited to systems containing sensitive or confidential agency and personnel data at the Office of Personnel Management, the Department of Education, Department of Labor, Department of Health and Human Services, Department of Energy, and Department of Transportation, and the Department of Commerce. Or any components of any of those agencies, or copying, transferring, or in any way disseminating any data from any of the agencies identified in this paragraph. That's so broad. That's super broad. All right. And then 2, terminating, furloughing, and otherwise placing on involuntary leave, whether paid or unpaid, any officers or employees of the federal government working within any of the departments, agencies identified in paragraph A. So, oh my gosh, other than officers or employees of the defendant entities, or directing any federal department or agency, not including the defendant entities, to take the prohibited actions described in this paragraph. All right, back up then. So this was our footnote we were taking a look at, footnote number 3 here. So here's our legal standard. What is it that the court's looking at? What rules does the court have to follow in order to be able to hear this case? And this was where some of the problems were. All right, so here we go. A temporary restraining order is an extraordinary remedy that should be granted only when the party seeking relief by clear showing carries the burden of persuasion. So she's saying this is, we only grant these in certain situations. How do you tighten it up and not leave room for a loophole? Great question. And, you kind of, one of the things that you really find yourself going through are situations where you tighten it up and then you give it to the judge and the judge says, no, it's still too broad. And then you tighten it up again and the judge says, nope, still too broad. So you have to kind of keep going through it and until you get to a point where the judge allows for it. So it's very normal for a judge to come in and say it's too broad and send it back, because that's what you need to do. You have to make it so that the judge finds it to be specific enough. And usually what you'll do is rely on precedent and other similarly situated restraining orders. So we've got multiple cases here that she's citing. As with a preliminary injunction, a party seeking the TRO must establish 1, he's likely to succeed on the merits, 2, that he's likely to suffer irreparable harm in the absence of preliminary relief, and 3, that the balance of equities tips in his favor, and 4, an injunction is in the public interest. So those are the 4, this is the test, this is the burden that they have to meet in order to actually get that restraining order here. Right. All right, number 5. Here we're moving over. A court also considers the underlying purpose of a TRO, preserving the status quo and preventing irreparable harm until it's had an opportunity to rule on the merits. So temporary restraining order is just exactly that, just a pause. Let's pause until we can fight this out in court. And temporary restraining orders are temporary by their nature. So they're not meant to be forever. They're meant to be for a couple weeks until you can, stand up in front of the judge and chat about what's going on. So keep that in mind as we go through this. We've got so many restraining orders right now that have been issued by so many different judges in so many different jurisdictions. And again, those are all temporary until the cases get in front of the bench. We're citing case law here, multiple different ones. The court may issue a temporary restraining order when a movement is faced with the possibility that irreparable injury will occur even before the hearing for a preliminary injunction required by Federal Rule of Civil Procedure 65A can be held. So the reason I think this is really important to note is because we've already got a case where we've got a request for a writ of certiorari that has been posed regarding, again, a temporary restraining order. That's already on the docket right now. So this rule and the procedures here are important to note, because this is really our first legal hurdle in a lot of these cases. Citing further case law, in the context of the limited purpose of a temporary restraining order, the court's analysis of these factors seeks principally to ensure preservation of the status quo. So they're trying to preserve what's happening right now so that damage isn't done until the court has a chance to take a look at it. All right. Next, we've got the analysis. So we've had the legal standard. So next we'll go through what the judge is saying, how that legal standard applies to the legal question here, and then the conclusions. The court's analysis here begins and ends with irreparable harm, and we're going to see this over and over and over again, everyone. A threshold requirement in granting temporary injunctive relief, citing further case law. To show irreparable harm, the injury alleged must be both certain and great, actual and not theoretical, beyond remediation, and of such imminence that there is a clear and present need for equitable relief. This is the test. This is what the plaintiffs have to show. And if they can't show this, then they don't meet their burden and the request will be denied. So this is really important here. We rely on these tests and burdens in order to go forward. That's why we're so thorough in the legal system. So this is multiple cases here. The possibility of irreparable harm is not enough. So just possibility. You need to show more than just, well, this could be harmful. And a plaintiff must demonstrate a clear and present need for extraordinary equitable relief to prevent harm. So it needs to be special. This needs to be a special situation. If a party fails to make a sufficient showing of irreparable injury, a court may deny a motion for injunctive relief. Again, that's our legal standard that we have there. And yes, I will stop for a tea break for 1 minute here. Right. Hello, Galactic Macaroni. That's such a great name. Oh my God. Yeah, well, so unique. That's a really good point, right? So TikTok came in and said we needed a restraining order because there's irreparable harm that's going to be done if we have to, go dark. And the court said, nope. And then later the U.S. Supreme Court was like, all right, do whatever you want. That's kind of how that goes. Next up. Again, we're going through further case law. Movements are barred from receiving such relief should they fail to establish irreparable injuries. Now, movements just mean the people that are filing the motion requesting that restraining order. On the record before, the court cannot conclude that the plaintiff satisfied the high standard for irreparable injuries. So she's saying, you guys didn't meet your burden here. Plaintiff's declarations are replete with attestations. I said it the correct way, didn't I? Attestations. That if Musk and Doge defendants cancel, pause, or significantly reduce federal funding or eliminate federal state contracts, plaintiff states will suffer extreme financial and programmatic harm. Number one, and then she's pulling out the pieces here. If the actions of Doge led by Elon Musk cancel federal state contracts or significantly federal funding from partner federal agencies, it will impact Washington State's ability to adequately serve and uphold its own legal commitments to its residents. Here, upon information and belief, if the Department of Labor's sensitive data is compromised, the state of New Mexico would be vulnerable to embezzlement, cyber theft, ransom attacks, and other financial crimes. See, and something, again, interesting when we take a look at the TikTok ban case, you've got people coming in here and saying, well, we're going to have all of this alleged harm is exactly what the government was saying about TikTok. Like, have they done anything yet? No, but we're worried about the harm. So it makes sense that these states are coming in and using that same argument here. But we've got courts saying, maybe that shouldn't have been done that way. Law of the Wild, hello. Attestations. Thank you so much. I appreciate it. Oh, my goodness. if existing programs are canceled or federal workers administrating these programs are terminated, the state of New Mexico will not be able to receive reimbursements. Connecticut's Department of Social Services funding is potentially impacted by the actions of DOJ. So potential impact, does that rise high enough to the level of there being some kind of significant injury? I don't know. Hello, Dolphin. Simply file protection orders. Oh, I'm not sure about that. All right, here we go. The court's aware that DOJ's unprecedented actions have resulted in considerable uncertainty and confusion for plaintiffs and many of their agencies and residents here, but the possibility that defendants may take action that irreparably harm plaintiffs is not good enough. Unlike the TikTok case. Oh my gosh. And then we've got case law being cited. Quote, feared possibilities fall short of the imminent threat of injury required to grant the TRO. So again, we've got significant, it's a high burden. It's a high test that they have to meet. But if you don't meet it, you're done. It remains uncertain when and how the catalog of state programs that plaintiffs identify will suffer. When litigants have identified specific individuals or programs imminently targeted by defendants, courts have issued appropriately tailored TROs. And we're citing case law granting TROs prohibiting further removal or modification and compelling reinstatement of CDC, DHHS, and FDA web pages. So the AIDS vaccine, this is an ongoing case, by the way. This is one that I've been following here. Granting that temporary restraining order prohibiting defendants from implementing the blanket suspension of foreign aid funding, but refusing to enjoin specific personnel or operational decisions absent evidence of noncompliance with the TRO. So one thing that's really interesting here is that, of course, all of our judges are going to be watching all of these cases. The cases are moving at different rates depending on jurisdictions. So we've got, this is a U.S. aid case here where they came in and said, all the funding's gone, we're destroying that agency. That's where this lawsuit came from. So our judges are watching. They're watching each other. They're looking and seeing what's happening in other places because there are so many cases. Conversely, when litigants have failed to show imminent harm, courts in this district have refused to issue emergency TROs. So she's supporting her decision here, citing further case law, denying that restraining order motion because plaintiff failed to show mere access to personal data by government employees who are not formally authorized to view it without more creates an irreparable injury. Citing further cases. This is another case here, the Doe case, where, let's see here. That's another one that's been filed. I can't remember off the top of my head exactly where that restraining order is. But yeah, it's ongoing. Plaintiffs have failed to demonstrate that there's significant risk that their government email addresses will be stolen or publicly disclosed in the next 14 days. The reason, again, why they're saying 14 days is because of that limited time period that our restraining orders are for. It's a temporary situation as well, and the court's going to take that into consideration. Plaintiffs asked the court to take judicial notice of widespread media reports that DOJ has taken or will soon take certain actions, such as mass terminations, but these reports cannot substitute for specific facts in an affidavit or verified complaint that clearly show that immediate and irreparable injury, loss, or damage will result. I'm going to take a minute and I'm going to say that's like the nicest thing ever. Like, we've got rules, people. We've got rules for both sides. You still have to follow your rules. Like, don't get on the crazy wagon and say, well, everything's all nuts and bonkers and out of control and blah, blah, blah. Like, no, dudes, like facts in affidavits. Like, we still do that. That's still required. Ah, my goodness. So, and that's according to Federal Rule of Civil Procedure 65 sub B sub 1 sub A. And then we also have another case backing it up here. The court may take judicial notice of news articles for their existence, but not for the truth of statements asserted therein, which again is one of the greatest things that I have read in the last 2 weeks. Like, preach. This is so important. Again, we can't get lazy as attorneys. We can't get lazy and start doing bad behavior just because, some of Trump's attorneys do that. Just because they do it and they get away with it doesn't mean that it's okay or that it should be trend setting. So that's very important to remember. Oh my goodness. Now, Law of the Wild, this is a family show. Oh my goodness. Oh. All right. All right, here's the quote. Someone said, can you say it again? The court may take judicial notice of news articles for their existence, but not for the truth of the statements asserted therein. So she's saying just because the media is out there reporting all of this crazy business doesn't mean that it's factual, doesn't mean that it's something to use to support your argument, as all attorneys know before everything went to crazy town. Oh my gosh. All right, just a minute. Frustrating. Seems like only one side has to play by the rules. Well, it is frustrating, and it does seem that way. But on the other hand, you got to follow the rules. You just have to follow the rules. And one side's cheating, and so you have to say, well, if you're cheating, why can't everybody cheat? And what my answer would be is you can do what you want to do if you're creative enough. Just do it within the confines of the law. And that's how it's supposed to be, right? So that's how that's what we do. And attorneys should be intelligent enough to get where they need to go without having to screw the rules up and cheat. Just because the others are cheating doesn't mean we should cheat, right? Because that takes the whole system down. The whole system comes down if everyone just starts, Wild Westing it. We've got the bank's case here, refusing to consider counsel's assertions during preliminary injunction oral argument, absence corroborating record evidence. And even if the court could appropriately consider the news reports in conjunction with defendants' vague representation that a select set of agencies in fact terminated a number of employees at the end of the week, that would not cure the motion's deficiencies. So she's saying, even if I did look at that stuff, which I'm not going to, it still isn't going to help you. Terminating thousands of federal employees may cause extreme harm to the individual employees and potentially the institution writ large here. And then we've got the Dellinger case. That's another one that's up on my closet door. And we've got an American Foreign Service, another one here. I'm trying to remember. I think the Dellinger v. Bassett, this is the Pennsylvania federal funding case, or the New York. Yeah, this one I think is a Pennsylvania one. And then this one is another one of the USAID, or USAID, USAID executive order. So, but harm that might befall unnamed third parties does not satisfy the irreparable harm requirement in the context of emergency injunctive relief, which must instead be connected specifically to the parties before the court. Plaintiffs have not adequately linked defendants' actions to imminent harm to plaintiff states in particular. So again, we've got those 14 states are the ones who have filed this lawsuit. So is it the employees themselves that need to sue? Yes, and they are. They are. Many of them are suing. I would say probably the strongest one that I have seen would be the NLRB woman who had been terminated from her position. Probably, well, and then also the Office of Special Counsel. And this isn't like the Jack Smith Special Counsel. This is the Special Counsel for like whistleblowing in the executive branch. And the person who was hired to do that position was given a 5-year appointment. And it's not been 5 years, and they just fired him. So they're like, dude, this is Senate approved. It was for 5 years. And so those, in my opinion, are the two strongest cases. But there are multiple cases where they're coming in. FBI, yes, that one I would say is a strong one as well. So moving forward here, everyone. I'm sorry, I get distracted. There are just so many cases. Oh my gosh, I have so many cases in my head right now. That said, plaintiffs raise a colorable appointments clause claim with serious implications. Musk has not been nominated by the president nor confirmed by the U.S. Senate as constitutionally required for officers who exercise significant authority pursuant to the laws of the United States, which is the same argument that was used by Mr. Trump and his team regarding special counsel Jack Smith. And again, that's a different special counsel. That was special counsel through the DOJ. And she's citing case law here, bypassing the significant structural safeguard of the constitutional scheme. Further case law, Musk has rapidly taken steps to fundamentally reshape the executive branch. Even defendants concede there is no apparent source of legal authority granting DOJ the power to take some of the actions challenged here. So it's nice that they just admit it. They're like, yeah, no, we don't have any authority, but we're doing it anyway. Like, oh, all right. Accepting plaintiffs' allegations as true, defendants' actions are thus precisely the executive abuses that the Appointments Clause seeks to prevent. But even a strong merits argument cannot secure a temporary restraining order at this juncture. All right, so here's footnote number 4. She's not saying the case isn't valid. She's not saying, well, it's not going to succeed going forward. No, that's not what she's saying. So she's being very precise about the request of a restraining order because it has a high burden, and it should have a high burden. Number 4, in some circumstances, constitutional violations may constitute irreparable injury. Citing case law here, plaintiffs have not identified, and the court is unaware of, any case granting a restraining order based on an Appointments Clause violation. That's because we haven't been in this situation before, and the D.C. Circuit has recently held that at least certain Appointments Clause violations are not without more an injury that necessitates preliminary injunctive relief. So she's not saying it's not an injury. She's just saying it's not an injury that rises to the level that an injunction is appropriate here. All right. Lastly, plaintiffs legitimately call into question what appears to be the unchecked authority of an unelected individual and an entity that was not created by Congress and over which it has no oversight. In these circumstances, it must be indisputable that this court act within the bounds of its authority. Accordingly, it cannot issue a restraining order, especially one as wide-ranging as plaintiffs' request, without clear evidence of imminent irreparable harm to these plaintiffs. The current record does not meet that standard. So, very, very specific and well written here. And conclusion, for the reasons explained, it's hereby ordered that plaintiff's emergency motion for a temporary restraining order is denied. It is further ordered that the parties shall meet and confer regarding further proceedings. If plaintiffs intend to move for a preliminary injunction, the parties shall file a proposed briefing schedule and state their positions on consolidating the merits with the preliminary injunction briefing. And again, this needs to be done by 5 p.m. today. So let's get that briefing in. So what have we learned? She's not saying there isn't any harm. There's definitely some harm, but the harm is not specific enough to allow for the huge burden that is needed for a temporary restraining order for injunctive relief. So it's just not enough. It's not enough specificity here. Do better in their case. So let's take a look. Let's smack it around a little bit and see what we think. Because we have here the list of what they've said. And she's saying it's not specific enough. So let's take a look at it. Let's try to see if we can figure out what would be something that they could change. So here's the first one they've got. They're ordering any change in the disbursement of public funds by agencies. All right. What is it we can add? What can the plaintiffs add to this to make this more specific? How can they make this meet Judge Chutkin's requirements? What language are we going to add? I'm sorry, I'm looking for a pen. I'm picky with my pens today, everyone. Picky, picky. Here we go. Picky, picky. Which agencies are involved? Right. So, list the agencies, right? List agencies. Specific agencies that are being harmed. There we go. Right? List the changes, right? So any change isn't specific. Well, what kind of change are we talking about? So let's be specific. Any change in the disbursement of public funds. So if we're talking about that, any addition, if we're adding or removing, even that change itself can be more specified here. Ordering that any addition or removing in the disbursement, right? That already would help us. A violation of specific contracts. Right. So let's put that in there, specific contracts. And then we also have, congressional issues as well, what's already been set out. And I'm just going to put a little note here for Congress because I think these two can go hand in hand. Special contracts as well as what Congress has already set out. How were they harmed? Quantity loss. So the harm issue is going to be difficult to really nail down because we don't have the harm yet. If I don't see how they would have the harm other than listing what could happen. So that's really one of the issues. Specific disbursements for different agencies. Yes, let's be specific with our disbursements. Specific. Right. Be exact with your numbers here of public funds by agencies. And so what should we do with the public funds? Time and manner, if other laws were violated in the process, discrimination. Yes. And I think that's really, again, the weakest link in Mr. Trump's administration is going to be the Administrative Procedure Act. I'm sorry, I was thinking of our disability funds that are being cut. So this is going to be the Administrative Procedure Act. So any of the administrative rules are going to be the weakest link for Mr. Trump. So that's just kind of how that is. Individuals being affected by job loss. Yes, that would be individual harm. We have to be careful when we're looking at individual harm because we have our states that are filing this. So you want to say, which is another piece that she had mentioned. So let's just take for a second here our list of states. She had said, so Washington had put out okay, this is how we're being harmed. And the other state, was it New Mexico? I think it was New Mexico that said we've been harmed. But where's the harm in Arizona? How is Arizona personally being harmed here, right? Be specific. What about Michigan? What has occurred in Michigan? What about California, Connecticut? So each state can come in and list specific to their states. So apply the situation to each individual state, right? So that would tighten things up as well. Termination of contracts. Yes, that's another, right. We're going to have a termination up here. Can't be harmed if they're non-existent. Acting like the federal system is an at-will state. That's exactly right. And puzzle, everybody. Fingers crossed. Did we make it? Oh, we did. Oh, shoot. One thing Mr. Trump's doing across the board is trying to make, civil servants an at-will. And civil servants are not at will. Why? Because Congress set the law out to say that they're not at will employees. If you want to get mad at Congress, executive branch, and Congress is based off of elected people. So these are people elected to these positions writing the law. So we, the people, said we didn't want our civil servants to be at-will workers in case some, jerk came in and started firing everybody. Right? First year people are being fired. Oh, yeah. I mean, there's significant harm. well, yeah, Project 2025. Yes. He's treating it like a corporation. Right. So when we're talking about, again, let's bring it back to our topic. We've got a temporary restraining order that's being requested. Judge Chutkin is saying you are too broad. You are not specifying the harm here. And because this is a high level, you've got a high burden to meet. So you need to show me, you need to be more specific. So what we're talking about here for this first one, ordering any change in the disbursement of public funds by agencies. So if we wanted to make this more specific, more narrowly tailored, what we would say, let's clear up any changes, any additions or any subtractions, right? Of certain amounts. So I would even add amounts in or types, right? So you could add certain terms like fundamental changes, or you could add terms like any kind of financial differences over a certain threshold, right? So we could add enough language to describe that change. And then let's be specific about that disbursement piece. Let's, exactly what you mean. What do you mean by disbursement? And then public funds. What public funds? Specify that by agencies. Again, what agencies are we talking about? Very specific. So, put those public funds and attach them to the public agencies. And then we also get into how each individual state is being affected specifically, by their first request in A. So that kind of gives us some kind of an idea of what she's talking about here, of what she's looking for. She's saying, we need this to be more narrowly tailored. I need more specifics here. And if you do that, then, we can talk again. And this is what we're talking about. So you need to sit down at the table again and try to figure this out rather than huge pieces. Brings down the state's credit score, unemployment rate. Exactly. How is each state being affected? What's going on in Arizona because of this? And then be specific to each one. So each one, they've got A through J. Each and every single one of these needs to be specific, needs to be tailored. Why does the restraining order have to be in place? What kind of irreparable harm is going to happen within the next couple of weeks if she doesn't implement a restraining order? Be specific. And so that's what needs to happen here without congressional approval. Exactly. So they're saying you need to stop DOJ from ordering any changes. Why? How is that change that they may be ordering going to give irreparable harm to the state of, Washington or Michigan or whatever? How and what kind of change? Is it just suggestions? Is it just, money? What exactly is that change? So narrow it down. Walk the judge through exactly what it is that is being hurt and what level and why it's irreparable. And that's what she's saying. Now we've got multiple requirements on that test. And let me see where our test is again here. See, these ones, they've already said we've got a little bit. They tried. I think they started going down the right road here when they tried to kind of say, well, this is how it would affect Washington. This is how it would affect New Mexico. What about the rest of the cases, right? Or the rest of the states? We do have, again, this is a 54-page request for their restraining order. And within this, they did give some examples, but it wasn't enough. It wasn't enough by any means. And so that's what she's saying. Give me more. Give me a hook to hang my hat on when it comes to this restraining order that you want. What about the loss of our representation? We elected people to do this and they're being ignored. Yeah, I mean, that's a pretty academic argument. That would be great for an amicus brief, in my opinion. Here, she you got to just narrow it down. What is it we're asking the judge to do? We're asking the judge to make it so they can't do these kinds of things until we argue it out in court. And if we lose in court, then they're going to be able to do it. right? But if we win at court, then the restraining order has kept us from being harmed irreparably until it can get settled out in court. All right. So those are the pieces that we're really needing to focus on. And again, let me put the test. Here's the test. Here's the test for the preliminary injunction. Let's take a look at it again. What is it that we need? What's required? As with a preliminary injunction, a party seeking a temporary restraining order must establish, number one, he's likely to succeed on the merits. Number two, he's likely to suffer irreparable harm in the absence of the preliminary relief. And this, again, is the key. Irreparable harm. Like today, right now, harm's going to be done, and there's no way that we're ever going to be able to make the person whole again for the damage in the absence of preliminary relief. And then next, and I would say one of the arguments I would make would be, well, if you got fired and later on we didn't do it right, we just give you back pay, right? So that can be taken care of. We don't need it on the front end. We can do it on the back end. Number three, the balance of equity tips in his favor. And four, an injunction is in the public interest, which I think would probably be their strongest argument, is the status quo is in the public interest right now. So don't don't jerk this stuff around. But their weakest link is this irreparable harm. What harm is actually being done? It's confusing, it's annoying, it's stressful, it's giving me significant emotional distress, but none of those rise to the level required to be able to issue a temporary restraining order. And this is really important because Judge Chutkan, I think, is acknowledging that we've got so many injunctions and restraining orders that are on the table here. So many. I mean, out of these 75 lawsuits, 50% of them have restraining orders being requested. And so this is setting precedent. Her decision here in the DC case, this is where everyone's going to look and see, well, she's got this restraining order. Here's the justifications that she put in. So she is the one who has the burden to really establish it. And it was the same with Mr. Trump's extrajudicial comments that he was making. So any of the comments that he was making outside of court, right? She was the one that had set this restraining order, and because she was so careful about it, she was able to make it withstand the Supreme Court scrutiny. All right? Everybody following that? Is everybody following that? Medical will be funny cuz. Right. Well, but there's a lot. There really is a lot. So there's a lot of damage. And again, we're looking to see what they're requesting. So the first one is they're saying, we don't want DOJ to order any of the changes in the disbursement of public funds by agencies. So have they, and that's the other question too, have they ordered any change in the disbursement of public funds? Has that already happened? Have they? I mean, that's a legitimate question. They've been doing a lot of other stuff, but have they ordered any of the places they've been to change the disbursements? Right. USAID, I think, is probably, or USAID. Sorry, I keep saying USAID. USAID is, I would say, the absolute top example, number one example here of what's going on. Yeah, it goes back to transparency. I agree. And we need transparency. FEMA, did DOJ cut FEMA? Or did the federal freeze cut it? And that's the other question here, even with the U.S. aid situation. Was DOJ the one that cut the aid? Or was it the executive order freezing federal funds? Or the executive order specifying U.S. aid be, destroyed? Which one did it? Which one? So DOJ is the one that told them to cut it, rather than the executive order, because we have a specific executive order regarding U.S. aid dismantling it. That's an executive order. That's not a Doge, a requirement. It wasn't Doge that came in and said, well, that's it. So you have to take a look and see where exactly what you think it was the freeze. Yeah, that's the thing. That's the thing, right? So they're saying we want to make it so you can't order any change in the disbursement of public funds by agencies. All right, but where's that happened? Where do we know that this is even an issue? So those kinds of questions we gotta figure it out. Didn't they take money back from New York? The Doge, did the Doge take the money back? I'm not sure. Fired nuclear state. Right. But did Doge? I mean, again, we gotta be very specific when we're dealing with. Oh my gosh. Oh, I've got so many people trying to bust in here on my live. I swear, everybody, I have turned off everything. I've turned off everything. I don't know why. Why do you keep coming back here and harassing me? All right. I'm just going to put that to the side there. No. This is the order. So let me do a review, everybody, here on our Lunch and Learn. We just Lunch and Learn, which my provost used to call this. I miss my provost. Anyway, here we go. So I've been going through this lawsuit filed against Mr. Musk and the Doge, and it was brought by the AGs of 14 different states. And these states are saying we've got some harm being done to us because of what Doge is doing. We want a temporary restraining order, meaning they need to pause it until we work this through the court system. Judge Chutkin came in and said, well, we've got a test. We have a certain order that we have to do things in and certain burdens that have to be met. And you did not meet your burden of being specific enough regarding the harm, irreparable harm that would happen if I didn't put the restraining order into place for a few weeks. So she's like, no. And if you want to go back to the drawing board and get yourself sorted out and figure out how to be more specific here, that's fine. And we'll set up a briefing schedule. We'll set up another hearing, I'm sure is what she's wanting to do. And she's saying by the end of today. So at 5:00 today. All right. So that's kind of that. Inadvertently made them have $80 million. Right. That, my understanding on the New York federal funds issue is that was through the executive orders freezing all of the federal funding so it could be reassessed. And there was a restraining order on that, meaning the people that have actually frozen those funds are in violation of a court order. Submitted by states today at 5 p.m. Yes, exactly. This is DC. Yep. So there you have it, everybody. There's the quick overview of what had happened out of DC. And do I see this as a loss? Absolutely not. I think I do not see this as a loss. I see this as, we've got rules, we've got burdens of proof, and the plaintiffs didn't meet their burden. So, go back, get it sorted out, meet your burden, and come back when you've met it. So I wouldn't say I'm frustrated or upset by any means. This is just how the system works. This is how the court works. And I think that was such a good comment for the person who had said, well, why do we have to follow the rules when the other side is cheating and not following the rules? And that's such a great question. And my answer to that is, we're smarter than them. We're more intelligent than them. And that's, if you're trying to cheat and go the quick and easy route, the cheater, and, trying to throw illegal punches and stuff, it's like, you guys are jerks and you're kind of dumb. But we're smarter than that. So we should be able to beat them on the merits. We should be able to win by using the law and going through the process. It takes more time. It's harder. It's stressful. It takes more brain power. But, that's what we do. So that's what the system's about. You got to follow the rules. Everybody needs to follow the rules here. Meals today. Oh, thank you so much. Oh, I appreciate that. Oh, my gosh, Shadow. Oh, look at that. Look how cute that is. Thank you so much, Shadow. I appreciate it. Even with the new EO. So I'm going to have to take a look. I'm a couple of EOs behind everyone. Spaghetti at the wall. Yeah, yeah. But, I mean, again, we've got a process. They need to follow it. We need to follow it. So everyone needs to be following the rules, and then we'll kind of take care of it. I know, Deborah. Right, right. It made a little noise. It's adorable. It was really cute. New ones are back. Yeah, yeah. I know. Oh my gosh. All right. Well, with that, everyone, I will go ahead and sign off for today. This was my midday. I'm gonna try to come back tonight. We will see. I can't guarantee it, but if I am able to come back on tonight, it will be over on my YouTube. So thank you all for coming and hanging out. Thank you for all of your hard work to my moderators. Hopefully, this kind of clarified the situation a little bit. This is going to be ongoing. Again, this is going to be one of those where they're going to try things out. She's going to say no, and then they're going to keep going back and forth and back and forth. Can you unblock? Oops, sorry, I just missed the name. Can you just DM me? DM me the name, and I will go back through. So take care, everybody. Have a great rest of your day. Thanks for coming and hanging out, and I'll see you all again very soon.